Good afternoon, everyone. I'm glad to welcome you, including those joining us online. The first of the seminars we plan to hold here in this room to discuss matters of constitutional law. The aim is to facilitate conversations on fundamental topical issues of constitutional law and practice. And today's event is brought together by the Department of Public Law and Jurisprudence, that hosts the MLA program of Practice Constitutional Law and the research chair for constitutional design in developed societies. Today, we are joined by Professor Francois from Northwest University, who are kindly to have a conversation with us on his new book, The Language of Constitutional Comparison. Professor Bennett, much for having this. Just to say a few words about Professor Bennett. Professor Bennett taught law since 1974 in the Faculty of Law in Potchefstroom, South Africa. He was Dean of the Faculty from 2001 to 2012. He's a multiple recipient of research funding from the Alexander von Institute for research into German institutions, and he's author of several scholarly monographs and several journal articles. And he's an NRF B2 researcher, which is a recognition of acknowledgement of the fact that by he, the researcher, that enjoys considerable international recognition by his peers for the high quality and impact of his research outputs. And he's currently extraordinary professor at the Faculty of Law, University. Maybe I just want to add two more facts about Professor Venture. One very personal to me. So a long time ago, I completed my PhD. Professor Venture was one of the 3 examiners, and I never had an opportunity to thank you for the very positive and critical report. That was a long time ago. And another fact had to do with his involvement in the drafting of the South African Constitution between 1990 and 1995. He was deeply involved in that process. In fact, he was one of the few constitutional scholars that played a role in the negotiation and the making of the South African Constitution. Some even refer to the Venter turning point. I don't know if you come across that. So it's a reference to a document, to a position paper that Professor Venter drafted at a crucial point in the negotiation between the National Party and the ANC. So Rolf Meyer, who was the negotiator representing the National Party, talks about, recounts this in his autobiography. And so when that paper, the paper that was drafted by Professor Venter, was presented to Ramaphosa, who was then the negotiator representing ANC, Meyer said, Cyril's eyes lit up. And after that, he said, it was plain sailing. And another report indicates that the document was sent to Mandela on July 2, 1992, immediately after the Boy Patton massacres. So it's clear that, as one author says, the Venter turning point came in the channel at one of the most difficult moments in the extended negotiation between the National Party and the ANC. I wish we could talk about the Venter turning point, but I guess that's a discussion for another day. Today, we're talking about his new book, The Language of Constitutional Comparison. So with these words, it's now my great pleasure to hand over the chair, physically, to Professor Leroux, who will lead the conversation with our guests. Thank you very much.
Thank you. Good afternoon, everybody, and Francois, thank you. Welcome. It's very great to have you here. So you've written this new book. As I read it, it seems to be a reaction, or at least a response to the current state in which comparative constitutional law, as we call it here, finds itself. So the title of the book is not comparative constitutional law, it is the language of constitutional comparison. maybe there already one sense interrogation of the language being used in the Ghanaian discourse. So as an opening question, maybe explain the title and use that then as a way of situating the book in the light of the current field of comparative constitutional law or constitutional comparison as you see it.
Yes, let me first say thank you very much for the invitation. I'm honored to be here, and thank you very much also for the kind words, Mr. Fisher, and for your cooperation with Professor to invite me. I'm looking forward to this discussion. Language of constitutional comparison, I think, should carry the notion that we are not dealing with comparative constitutional law, which is a concept that was, I think, actually designed by US American professors of law when they became interested in comparing constitutional issues. And the reason for this particular phrasing, constitutional comparison instead of comparative constitutional law, is that one gets the impression from outside, if you read comparative constitutional law, that you're going to be confronted with a set of norms, which is not the case. Doing a constitutional comparison, which, by the way, became a passion for me in 1990 when we were doing a lot of research for the purposes of advising the negotiating process. Doing constitutional comparison is an activity. It's not a set of norms. But now, constitutional law as such, having developed over many centuries, especially from the background of what I call in the book the North Atlantic states, as they are now recognized, developed a language of its own. And this language is based on the philosophies which actually inspired the two great revolutions of the late 18th century, the American and the French revolutions. And the philosophies, or philosophical theories on which those revolutions were based was clearly liberal. Liberal written with a capital L, based on the points of departure of liberalism, focusing on the individual's freedom, and the role of the individual in public matters. Now we're in this 21st century, where that language has become contested from various perspectives. Probably because the notion of constitutional liberalism, or if you wish, liberal constitutionalism, seems to be losing traction. Not only among scholars, but also in practice. And that we see, especially, I think, in the rise of populism, especially in liberal democratic countries. There are many examples. I don't think I need to quote those examples. The latest is Italy. Hungary became a populist state, developed a populist constitutional approach after having become a liberal democracy. and one sees this also in, especially in the latest, I think, contestations in the United States elections. But I think I should stop there, so we're not get bogged down in certain things.
So, just although you say you want to stop there, when I read the first chapters, there was a vision there of a dystopian future around the COVID-19 pandemic and lockdowns, as if this is the future that we're heading to. So that will become the new normal, this kind of securocratic lockdown, authoritarian state. And the implication seems to be that you suggest that the dominant language of liberal constitutionalism is incapable of responding to this threat. And that's one of the problems of that language. The second problem would be that it is hegemonic, and therefore everybody is forced to speak in that language, effective as it is. Is that more or less a correct assessment of your take of where we are, where we're heading?
Well, dystopian is a very strong word. I wouldn't like to be associated with a dystopian view of the future, but obviously the book was written during the pandemic. I had lots of time sitting at home. I often joke saying, well, there was COVID, I had to stay at home, so I decided to write a book. That's not quite true. From that perspective, I think one could see, and there have been quite a number of publications since then, that the circumstances of a pandemic as the one that we recently experienced tends to overtax constitutionalism in terms of the absolute necessity for the state to take steps that they would otherwise not be allowed to take in order to deal with such a crisis. I wouldn't like to go into that too much. The perspective that one can get not only from our experience of COVID and the pandemic and the implications and so on, but also from tendencies in public life around the world, is that we seem to be balancing on a point where a kind of a phase of political and constitutional history is passing. And we're moving into something new, which is unpredictable. For various reasons. One of them would be economic, for example. The fact that the People's Republic of China, as the second largest economy at the moment, the United States of America and some other countries in their political and constitutional activities, often, if you'll excuse the strong expression, show tendencies of soap opera. Soap opera around Brexit in the United Kingdom, and more recently the quick changeovers of prime ministers and so on. These, I think, are symptoms, and actually this is political comment, not really constitutional comment, if you excuse me, but these two subjects are so close to one another that you can't often distinguish them completely. But the point is that things like that seem to indicate that we are moving into something new and we don't know where we are going. And the point I think I would like to emphasize, and what I wanted to emphasize in the book, is that we do not really have the language at the moment to deal with this coming change. Perhaps I should just give one example. Constitutional law, or the language of constitutional law in general, is based universally on the notion of the sovereignty of the people. Now, unfortunately, if you look at that notion closely, it is a fiction. There's a contradiction in the idea that the people are sovereign, and then through certain processes they transfer their sovereignty to a government or the state. And now the state is actually sovereign, because the state is in a position to prescribe in the most fundamental details what the sovereign people may and may not do. That's law. So this contradiction is something which we have inherited from liberal constitutionalism, and we don't have the words to deal with this change. And just one other point. It is even in the non-democratic states where this language, which is the only language available, is being used, such as the Democratic People's Republic of Northern Korea.
Thank you. So on that point, so the book contains this introduction, as I tried to, and Francois tried to explain, and then goes into 8 substantive chapters, where you take key concepts of this dominant language and orthodoxy, and you deal with each one of them in an interesting way. Something that reminds me, I said it earlier to you, of the trashing undertaken by the critics in the 1980s to expose these contradictions that you just spoke about, the mystifications inherent in the language. Now that seems to me to be an interesting response to the claim that we lack the language. It's as if you want to make sure that we generate a new language by exposing the limits and the contradictions of the existing language. Do I understand the gist of those 8 chapters correctly, that you're trying to expose the contradictions, the incoherencies inherent in our constitutional language, in the hope that thereby a new space can be created for a new language, or a more precise understanding and use of this language? So, is the aim to generate a new vocabulary or to clean up the existing vocabulary?
When one writes a book like this, you need to curb your ambition. My ambition was not to establish a new language. That's that would require not a book, but it would require a few decades of coherent scholarly and public effort. What I wanted to do was to not to trash the language of liberal constitutionalism, because that's all we have at the moment. We can't discard it. It's there. But to point out, especially in the context of constitutional comparison, that if you use those words, you are losing or discarding the value of your comparison if you don't explain yourself. If you use the word democracy, for example, left, right, and center, without saying exactly what kind of democracy you are talking about, but a better example would be rule of law. When a German constitutional scholar speaks English at a comparative conference, and they say rule of law, they mean something completely different from what the British and the Americans, they have a different concept, Rechtsstaat, in mind, but they use rule of law. So, like ships passing one another in the night, I think that happens quite often. And it shows to my mind, the quality of some of the comparative work that is being done in constitutional law. The most productive comparative work, productive in the sense of volume, is being produced by the North Americans, especially in the United States constitutional lawyers. And they simply assume that their language, in most cases, I'm generalizing, but in most cases, they simply assume that the language which is current in American constitutional law is universally valid. It simply isn't. So, what I did in some of the chapters was to investigate as objectively as I could the development of some of these of the relevant concepts historically and theoretically, and then at the end, in some cases, I tried to draw the most essential elements that can possibly be understood as universally true, which is very reduced meaning in every case. More for my own purposes, not to try to persuade other people to use, that time. What I'm trying to persuade people to do in the book is to say what they mean before they say it. Just an example, let's stay with the rule of law. It seems to me that two elements that you can find in the rule of law, which is probably universally true, is predictability and non-arbitrariness. If you go beyond those two, you run into shall we say, difficulties of point of departure.
So then if you tackle these concepts that you identify, just as a way of methodology of the writing method, the chapters tend to deal with the use of the term in literature, in constitution, selected constitution around the world, sometimes case law. So how did you go about, is it a question of doing a word search to identify where this concept appears? Or how do you then select which of the usages of this concept around the world to select for the chapter? Can you just unpack a little bit the methodology, not only in this book, but also in I think the South African Law Journal, the South African General Human Rights article that preceded this, where you looked at the way the Constitutional Court uses a specific term. How your methodology of putting this together before we move on, if you care to share that with us.
That's a difficult question because one's methodology is often determined by the particular topic that you're working on. Some topics would require a thorough analysis of the history of the notion, of the concept that you're working with. That was the case in quite a few of these, the themes of the various chapters. Because I believe that in comparative work in law, generally, the constitutional law particularly, comparison can't really be done without determining where the concept you are working with are coming from. So that's one methodological concern. Another concern or another factor that one needs to take into account is which of the different constitutional orders are most influential at the moment. It wouldn't, for example, serve much of a purpose to study the notion of democracy by comparing, let's say, Rwanda with Sri Lanka. One would have to go to the constitutional orders where one sees that their influence, their impact in literature and also in practice are greatest. And it's actually a strange irony in a certain sense that the whole world is bound by the language that developed around the North Atlantic, mostly in the 17th, 18th, 19th centuries. And I don't think people always realize it. For example, in doing my reading, I found that both the Chinese constitution, current Chinese constitution, and that of the Russian Federation took the United States Constitution as a kind of example in their terminology. So I hope that covers your question, history and impact. Now, you refer to word searches. It is indeed possible nowadays to do quite a lot of research by simply sitting in front of your computer, doing internet searches. The problem with that is you often land up with so much information that you've got to have some kind of a standard to measure them. More useful is not only, I'm not talking about Wikipedia and so on, that's very dangerous. I'm talking about electronic books and other publications. It's very useful to troll through them to try to establish where the strongest impact is to be sourced from at a particular point.
Could I perhaps at this point also then ask you to explain the epilogue at the back of the book? Francois reflects on his own methodology and the selection of the material, which I find very illuminating and welcome. And there you make a distinction between being objective and being neutral as a legal scholar and comparativist. Maybe you should just explain the difference to us and the relevance of that insight, that distinction for your own work and for the book as a whole.
Thank you very much for that question. That's my little hobby horse, as a matter of fact. In liberal constitutional orders, the way in which the law and especially the courts deal with matters of worldview, religion specifically, is to say that the state is not involved, should not be involved in those kind of matters, ideological or religious matters, or especially not the courts. They should be neutral. Now I started digging into what this neutrality actually means and found that neutrality has become a kind of a notion that courts hide behind when they have to deal with intractable problems. You see it, for example, in judgments of the European Court of Human Rights and other European courts and also national courts in Europe and in the United States and in Canada and so on, where in many cases, judgments where courts have to deal with these questions, they base their approach, some base their approach on neutrality of a certain kind, and others would base the minority judgment, for example, on neutrality of a different kind. My contention is neutrality is impossible. We all have, as human beings, a perspective on life. And the foundation upon which one sees the world will determine your views of the law, your views of everything, as a matter of fact. Let's call it worldview. That's a very useful concept, one's basic premises. Now, my argument, and I did it in a previous book as well, that dealt with constitutionalism and religion, is that for a court, for example, and for anyone else dealing with the law. When you deal with difficult issues of fundamental differences in approach in religion or ideology and so on, you can't hope to achieve justice or fairness by means of hiding behind neutrality. You need to say to yourself, I need to be objective. And that's completely different from neutrality. If you are objective, you say you want to be objective. The first thing that you do is that you recognize your own prejudices. You recognize the fact that you have certain preferences regarding the issue you need to deal with. And then you have to take a conscious decision to deal fairly with the problem that you have in front of you, especially a court where there's different parties. Now, what is fair? Again, that's not quite so easy. But I think there is a solution, and I've been promoting the notion of what is called the golden rule. Doing to others and do unto others that you want them to do to you. That's a biblical quotation, but interestingly enough, this notion predates Christianity. I think Confucius was the one that one knows about that first came up with this. This whole idea of the golden rule might be a route to achieving objective results in a fair manner. Now, obviously, one can spend much more time on this one.
Thank you. Yes, we're running out of time. We want to open the floor. I've got two more questions, or maybe three, but the first one deals with the title again, with language. And the problem you see with a lack of precision in language. You compare the natural sciences in comparison then the exactness of terminology with the wishy-washiness of the humanities and the social sciences. You say at this point there that the constitutional language we use wasn't designed as a legal language. That's one of the big problems we deal with. So that can be understood as a benefit or as a disaster. I suppose from the benefit side you can say the generality, the openness, the vagueness of language, the lack of definitional clarity is exactly the opening for an imagination of something different. Or one could say we have to turn this language that was born in morality or religion or political science into a legal language by getting more precise and finding definitions. So my question is, which of those two responses you adhere to, or in which mix? It seems to me at times you want to crash, as I said, or deconstruct the definitional preciseness of language without placing anything in between, or to replace that. But at other times you come to the end of these chapters where you said you distill the essence of the concept as the roots of a new definitional approach. So it's not clear to me where you stand on this issue of preciseness and whether language and law, whether the lack of preciseness is a benefit or a disadvantage.
I think one of the greatest benefits that we as lawyers have is that almost the only instrument with which we work is language. If we didn't have language, we wouldn't have needed lawyers or courts. Then one could have simply, used computers to solve problems. Now, in scholarship, in the scientific world, we have on the one hand the so-called exact sciences, physics, mathematics, and chemistry, and so on, where the approach is usually that there are, if you follow a certain methodological process, you develop hypothesis and you do observations and you experiment, you come to a certain conclusion, you develop a theory, and that's for the time being what you're working with until the theory is disproven in the same manner. in law, we can't work that way. In the humanities in general, it's impossible because we're working with a moving target. We can't expect legal language or the language of sociology or history or whatever to be so precise that it is incontestable. There would be people, I can imagine, that would strive for that kind of precision. They would probably mostly be called positivists, which I didn't want to be associated with. But the fact is that we can't escape language. We have to communicate. The only means of legal communication is the words that we have and the grammar and the contextual application of linguistic notions. So one could perhaps describe it as a kind of a sliding scale. We can either have language of free for all, where words being only what you want them to mean, anybody wants them to mean, towards more precise and settled meanings. My argument or my ambition is actually to prompt people, even if they, especially if they have different views of particular legal constitutional concepts, to say what they mean, and not assume that what they are saying will be accepted by everyone else. That kind of arrogance is something that one does find in comparative working constitutional law. And without saying it expressly in the book, I'm trying to warn people against that.
Thank you, Francois. I think there's 15 minutes or so left. Maybe I should stop asking you questions and we should open it to the floor here and to people at home or wherever you're watching this. I think let's give the people here a first choice. So if you want to, yes, Angela.
Thank you for that very insightful presentation. It's also so nice to hear someone from my alma mater speak. I find the research very interesting and I have two questions, if I may. The first one is about methodology, and I wonder if you would describe your method as a type of a discourse analysis, or if you think discourse analysis would be appropriate. And then the second question I have is, a lot of my research at the moment is on adaptive law, specifically in the context of climate change, also as a threat and something that will cause challenges in a dystopian future similar to COVID. And the premise is that law is rigid and inflexible and doesn't allow for adaptive capacity and change in governance structures. And that sort of is contradictory to how I think we conceive of the Constitution and rule of law and what a Constitution represents. So I'm wondering if you can comment on what you think challenges like climate change mean for the current language of constitutional law and values, and that conflicts a bit with this movement in academia now to say that we need to work towards adaptive law and adaptive governance. Thank you.
Difficult questions, but let me start with the first one. I'm not sure if I'll be able to answer the first one. But climate change and the climate crisis that we're experiencing universally, it's a global issue. COP27, for example, scratching on the surface of the problem. I think one should see as one of the factors that would inevitably influence where we are going after the tipping point that I was mentioning earlier on. We don't know where we are heading exactly in terms of challenges to state sovereignty and the capacity of the law to deal with crises such as the pandemic and climate change. Climate change seems to be a rolling wave which is increasing and collecting momentum as it's going on, and we're not attending really to the possibilities of how to deal with that in terms of the law in general. I mean, I don't know very much about environmental law, but I know that, you know, people, again, that perhaps demonstrates one of the points I'm trying to make in the book. It again depends very much on one's approach. Not only methodological approach, but your worldview. What's it called again? The Earth jurisprudence or something like that, which takes this point of departure that the world and everything in it, apart from humanity, has rights which need to be protected. That's a huge jump in terms of traditional legal thinking. People are experimenting very much as you are in terms of dealing with environmental change by using the law. Whether the law is capable of making a contribution is still debatable. Although one could also say it is inevitable that the law will have to play some kind of a role. But one can fear, this is not a dystopian view, this is, I think, realistic. The world and countries, states, can be overwhelmed suddenly with the need to deal with a situation that the law has never even thought of before. So I think the task for us as lawyers is to try to imagine situations that are not there yet but are probable to develop, and then to, on the basis of the capacity of the law, which is limited, to develop possible solutions. Your first question, I'm not sure that I understood it, but perhaps we can discuss that later on.
Just use the mic.
Thank you for the presentation. I have 3 questions. One, can constitutions be neutral about ideology? Aren't all constitutions embedded in some kind of ideologies behind?
Can I answer the questions? Otherwise, I maybe forget them.
Okay.
I think all constitutions are based in some ideology. And the point really is that they almost all of them use the same words. I mentioned the example of China, North Korea, and so on, where peoples and democratic are concepts that figure in the title of the name of the states that are established by their constitutions. And their constitutions also say that the people are sovereign. And we know the people is very far from sovereign. It's a party. So that's one example. The South African Constitution, by the way, that can be a long story as well, was founded also in the current notions of liberal constitutionalism with elements of social democracy as it was understood in the early 1990s. The irony of that, and I wrote an article about that, and I won't bother you with all the details, but the problem with that is that none of the parties involved in the designing and development of that constitution supported either one of those notions. And that's one of our biggest problems at the moment in this country. Leave it at
May I continue with the next question? So if liberal constitutionalism, as you say, have a problem, what is the alternative is the next question.
I wish I had an answer. Constitutionalism, with all its different meanings, the number of adjectives added to the notion of constitutionalism is almost increasing daily. With people latching on the word constitutionalism, putting a different adjective before it to mean something different. But constitutionalism, as understood in liberal democracy, is still the vogue. The fact that we have constitutions and bills of rights protecting individuals, enforcing a distribution and not a concentration of power in individuals or individual entities in the state, those are obviously good things. We shouldn't even think of discarding them, because that addresses the core problem that constitutional law is there for, to avoid a concentration of power and to distribute the authority available in the state in order to serve the interests of the whole citizenry. And an alternative will have to be developed if at all possible. I think the Chinese are working very hard, not necessarily focused on replacing constitutionalism, but they've been developing a system which is very autocratic, but which allows a measure of a free economy. That's one possible direction in which it may develop, and it can become dominant if China as such becomes the dominant state in the world, replacing the United States and Europe. But that's speculation, and I do not have I can't offer an alternative to constitutionalism.
And the third is, can still comparison be made of constitutions with varied ideological underpinning, or should the comparison be confined to constitutions which have similar ideological background? Thank you.
That is a fundamental question concerning comparative methodology. There are different schools of methodological approaches to constitutional law. The basic one, which is mostly followed, is functionalism, which was actually inherited from private law, comparative law thinking, which works on the basis of formulating a function to see how this function is actually, shall we say, rolled out in different. Then another approach would be one that constantly looks for differences instead of similarities. The functional approach tends to focus on similarities. The postmodern approach seems to favor differences and so on. So again, the answer to your question is one of your choice of methodology, and that really is also a huge topic on its own.
That gives us more time here. One more question perhaps before we close.
Can I ask a question? So, in one of the chapters dealing with democracy, we try to problematize the idea and also the operation of democracy as we understand it today. And you talk about the European Union, for example, how the democracy deficit in its operation has increasingly led to questions about its legitimacy. enforcing decisions directly on citizens and the societies, passing over the governments and members of the European Union. Now, we have similar attempts in Africa, the African Union, which also tries to define itself along the lines of demos with the people of Africa. But it hasn't yet faced the kind of backlash that European Union has faced. And I'm just wondering why that is the case. Is it something that's still something waiting? That's how yet to happen. Does it have to do anything with the fact that the African Union hasn't been effective in directly affecting citizens and societies? So I just want to know what's your take on that. Thank you.
I would speculate that the answer to that question is to be found in the impact that each of these contexts have on the lives of the citizenry. In the European Union, the fact that there is a supranational structure with considerable powers, which isn't actually established in a real democratic manner, or doesn't really have democratic impact in the same manner as the national parliaments would have, for example. Europeans in the European Union's context, I think, feel and see the effects of this dichotomy more than we do in Africa. Because of the, possibly hopefully growing impact of the African Union, but it's not there yet. The other side of the coin is that ethnicity is probably, and I'm not basing this on particular knowledge, but my objective observation is that ethnicity is stronger still in Africa than one would find in Europe, generally speaking, a stronger factor. And ethnicity and supranational democracy, I think, are two opposing notions. Much will still have to develop. Perhaps I should, if we're closing, just make this one remark that, interestingly, regarding South Africa, shortly after 1994, we heard the notion of nation building used very frequently by Nelson Mandela. It's quite a while since I've heard this word used. It seems as though people have given up for creating a South African nation and therefore, shall we say, a consolidated democracy.
That's a provocative statement that could have elicited further questions, but let's leave it there. So Francois, thank you from my side for putting in the hard yards, sitting down, writing this book, giving it to us. It's something that we will read, I'm sure, and study, and it's a very useful book. If you've got students setting up postdoctoral studies to, as Francois says in the book, alert them to watch their language, to count their words. Just as an exposure of the difficulties involved in using these bread and butter terms, so that they can qualify what they say or use. Just for that practical purpose, I recommend the book. So I would have now called everybody to the front to have a signed copy, but as you can see, we live in an online world, we don't have many copies here. Thank you very much for your time and for everybody here listening to us. Jock, are you going to say the last word?
It's really been fantastic for me. So, yeah, this is new. This book tag's here at the back, so congratulations to Wes and Yolanda for the idea. And to have Francois back here, he was my lecturer, how many years? Almost 40 years ago. So, fantastic to have
Dan gaat niet eens voor mezelf daar.